Good afternoon and welcome to this special SILS virtual lecture with Ann Klinefelter. We're so happy to have Ann with us today. Ann is an expert in privacy law. She gave me my talking points several years ago about what the Europeans call dignity, which is an interesting way of thinking about privacy. Ann is the director of the law library at our law school here at UNC, and the Henry P. Brandis Distinguished Professor of Law. She has been researching privacy for quite a number of years and had a Fulbright in 2019, where she taught privacy law at the University of Helsinki. We're really pleased to have Ann here. She's a leader not only in the law, but in law libraries. And I think you're going to enjoy what she'll share with us today. So with that, Ann, take it away.
Hi, everybody. I'm so pleased to be connected with SILS and to gather with you all today to share some things that I've been exploring both through my Fulbright experience and from teaching at UNC, and have always enjoyed the opportunities that I get to be an advisor to master's students, PhD students who are writing in these areas, and look forward to conversation at the end of this presentation. I have shared my screen. I hope you all can see the slides. If anyone can give me feedback to make sure that that's working.
Yep, I can see it.
Okay, excellent. All right. Well, so I'm just going to try to give you an overview, because this is a point of friction right now that's in the news about the United States and the European Union. We do have a lot of business that's transatlantic. And so trying to figure out whether the Europeans will let the data about their citizens come to the US has been a big topic of conversation among people who care about this. And that includes a lot of people who work for platforms, any employers that process data over here that employ people in the EU. If you sell things to people in the EU, there are a lot of reasons why we care about what their law looks like and in comparison with ours. And I'm going to explain some of that as we go through. And I'm happy to get into a little deeper dive on any of these points as we get farther along, okay? So just at the beginning, to look at, we have the United States and we have the European Union. So there are 50 states, and there are 27 now, member states of the European Union. And it's not dissimilar, but it's not exactly the same. We have a strong history here of an interest in what we call states' rights. There are states who pass their own laws, their own privacy or data protection laws. And, there are different cultures in different states. It's a big tension, actually, between states' law and policy and the national law and policy. And the same sort of tension exists within the European Union. But there's a sense that there's a lot of strength that can be gained from that union. The European Union is a political and economic union, distinct from NATO, which is also in the news. So that's what we're looking at the outset. And then the foundations of privacy and data protection differences. In the United States, we don't have the word privacy in our Constitution. It does not appear. So we talk about in law and about whether we have, we have due process protection against the taking of any rights. And what those rights are is sometimes left to be imagined. We might talk about them as things that have just always been there, traditional values and rights. And then Then we have other things that are explicit. So we talk about those as our Constitution is sort of a source for civil rights and protections. And then we do have some law that has interpreted in some Supreme Court cases that speak about, different kinds of privacy rights, whether it's decisional privacy, which is also in the news, or whether it's information privacy, which seems to have an even more shaky ground at the Supreme Court, because these are not articulated in the document, the Constitution, the Bill of Rights. And we also talk in our country about data protection and privacy almost like they're one thing. We blur those, we don't talk about them distinctly unless you're in a special conversation. However, in the European Union, they have a Charter of Fundamental Rights, a sort of human rights document. And in that charter, they actually have distinct data protection and privacy rights. So they may overlap in application when things come up, but they are really the same. They are really distinct and explicit in the Charter of Fundamental Rights. So just to show you, you could take a magnifying glass. It's not going to help. We don't have that in our, we talk about liberty. We talk about a lot of other things. We've got the Fourth Amendment, which protects you against unreasonable searches and seizures. You must have warrants. There are other kinds of protections. Even the do not quarter troops in your home is a sort of privacy. There are a lot of things that emanate, to coin a phrase, from different rights that are explicit that would suggest privacy was important to the founders and is still protected. We even have found some anonymous speech rights that have been derived from the First Amendment. So there are some privacy, but you have to look carefully, and they're derived. So however, I don't know if you can see this small print, but in the Charter of Human Rights for the European Union, under freedoms, they start with a right to liberty and security and move straight into private and family life. And then the next one, the next interest that's protected is personal data. So it is a specific right in the European Union. So what we have, another point of comparison is that in the United States, we have what is often the metaphor is a crazy quilt. Like you have all these different disparate things that are put together that form our privacy law. They could be probably, think about HIPAA for healthcare providers and protected health information that is covered by insurance, electronic health records. And then we have banking law, we have the Video Rental Privacy Protection Act. We have very specific laws that protect privacy at the federal level. We use the Federal Trade Commission Act, which protects consumers against unfair, deceptive trade practices. And then we have all these different state laws that may apply to people who, if you are selling something to someone, say in California, you better check what their privacy law is. So we have just this, it's a real complex. There's the Driver's Privacy Protection Act for the information that you share with states. There are the Can-Spam Act, which has to do with, getting unsolicited phone calls or text messages, that sort of thing. So there are many different laws to look at in ours. And in contrast, when you look at the European Union, they just moved in May of 2018, the new General Data Protection Regulation replaced something that was a little less centralized. Their data protection law became more centralized. And so the idea was that they really wanted to have something that is more standardized throughout the union, not only to give people the same level of protection, but also to encourage the free flow of information throughout the European Union so that people would know, oh, I have the same protection, so I can share and data can flow. And so it's supposed to be good for business as well. So as I was saying, we have the Federal Trade Commission Act, which protects against unfair, deceptive trade practices. So this is one of the major laws in the United States, and it is representative of this idea of we're protecting the consumer. We talk a lot about consumer privacy, and we are very focused on what is the harm, what specifically is the harm. And so you have to prove and overcome other interests, competing interests like, fun, people making money from your data, and even things that we would all probably agree are quite compelling. There are all kinds of solutions to problems that we might discover through analysis of data. So there are a lot of things that come into the conversation, and so we really require in our political context some articulation clearly of, okay, so you care about your privacy, but how much and what specifically are the harms? And privacy suffers from a lot of vague sense of what it is that is your harm. And as Dean Marcinini was saying, in Europe, they have much more comfort with these vague concepts like dignity. Dignity is one of the first things that's in their Charter of Fundamental Rights. And they're very interested in how all of their political entities are going to protect these rights for them. So they talk about data subjects, which is a broader concept actually than a consumer. And so their law is much more broad. It's also very complex. It's 99 articles and a lot of recitals, which are like preamble, sort of whereas type discoveries at the beginning of it. So the defaults within these laws are probably what show how different our approaches are. In the United States, we really think of liberty and negative rights. When we look at the Bill of Rights, are really about Congress shall make no law. That starts the First Amendment. The idea is that these are protections against an overreaching authoritarian government. We want a lot of liberty from government. And we know that's how our country began. So that is deeply embedded in our notion of individual citizens' relationship with a government. And so if we were to have a law that were to restrict the use of data that people get about you or that you inadvertently or on purpose share with people, that would require government action. And so it's restricting liberty. And so most of our law is really as a default, go ahead and collect and use it unless there's some kind of prohibition. Now that's different in the European Union. Then you must have a permitted purpose in order to use data. Now there are many exceptions and ways of articulating what is permitted, and the purposes have to be articulated and consented to, or they are exempted in certain ways, but they're very constrained. And so it's just a different way. Now we may get to a similar space, but we start with a different way. So the idea is that in the European Union, they produce law to protect your rights, rather than you have rights against law being made that affects you. So what we're doing in the United States right now is we seem to be having a lot of innovation at the state level. So we have new defaults for consent in some states, new access rights to data about yourself, and there are biometrics restrictions. Like Illinois was one of the first to pass a law that gave people a private right of action. You can sue for money if your biometrics, like face recognition, is used without your consent. And at the European Union level, that is where most of the innovation is happening. Now, a lot of my study was on how they've implemented different ways to balance, because there's still a lot of deferred solutions of balancing competing interests that are embedded within the European General Data Protection Regulation, the GDPR. So it's not really all that centralized when you start getting into the weeds. There are a lot of things that are left for the states. But I also want to put California up here because California has one of the first and is state laws that seems to have a lot of components that harken back to the language of and some of the protections of the Europeans' GDPR. So we're seeing a lot of innovation, and there are other states. Colorado has a law now that's a general privacy law. Utah just passed a law. Virginia has a law. And there are a few other states that have biometrics laws specifically. So this is a very active area, and there are a lot of states that have pending legislation that has not yet made it forward. We even have some pending legislation at the federal level, partly in response to the confusion of these trends in state laws. If you are trying to comply with some of these state laws, it's very tricky because you have so many different things to tee up that are different depending on if you're a customer or is in a different state. So we'll see. There's a lot of momentum for having a federal law that would preempt these state laws. So, but the balancing with other interests happens a little bit differently. At least in the United States, we talk a lot about the primary value of freedom of speech, freedom of the press, and maybe even what we might care about, if those of us who are librarians, a right to receive information. But other interests don't have to be rights, and we're not entirely they're civil rights based when we talk about privacy and data protection in the US. Just business, this is the way business works now. It's all data driven, and we solve a lot of problems. Maybe we would solve healthcare problems. Maybe we would solve traffic and accidents and all kinds of environmental issues if we could look at more data. In the European Union, they also articulate expression and information, which is the right to receive information, in their charter, but they may be co-equal with privacy and data protection. I would say in the United States, speech rights, expression rights are primary. And then you have to show that a privacy burden is required, and it's narrowly tailored to avoid overburdening our First Amendment rights. In the EU, they also have business rights in the charter. And so and they also care about problem solving. So all of these things, it's very difficult to try to figure out how to come up with a solution. And that's reflected in some of the deferred solutions in the European law, and certainly in our struggles to come up with solutions in the US. The remedies that they have in our United States and the European Union, we have some private rights of action, which is how you file a lawsuit and get into court and get some individual money. There are other types of remedies that can be attorneys general who go and investigate and impose fines. That's how the Federal Trade Commission works at the federal level. Now, if you have a federal law and you had a private right of action, we're having some difficulties getting into federal courts because they want a very clear, concrete harm, and a lot of privacy harms don't meet the definition that the courts are seeing now. So even when there's a law that allows that and you see a technical violation, it's very difficult right now to get through into federal court. We also have some difficulties with remedies against the government right now because we have what's called the third party doctrine. I wish I had my party hats, but the idea being that if you've shared information, say with your bank or your credit card company or your phone company, then you've already shared it. Why shouldn't the government have it? So that's considered voluntary sharing. And we've only had one retreat from that rather porous ring around private collectors of information being required to share with government or able to, and that is cell site location data. But we can watch this space, it might change. And in the EU, there's some compensation for harm, and they have huge fines. This is what has really gotten attention. There are 2 tiers of high fines, depending on many different factors or several different factors. But one is 2% of global revenue for the prior year, and the other is 4% of global revenue. And that's because they were finding that big platforms and actors, especially United States companies, were sort of like, mosquito, So they really wanted to make the fines high. You also have other kinds of rights. You can get information about yourself and have it portable to another platform. There, you can withdraw consent. You can ask for it to be erased. You can get a copy of your information. You can make sure that it's correct. So there are many different rights that individuals have under the European law. So new laws on the horizon, I alluded to this a little bit earlier. There are definitely states, there's so many states that have these laws in the queue, and they are hot for people who are doing business through the internet, or so you really have to pay attention. Some of them require particular notice about what you're doing with data and opportunities to consent or not. And it's likely that we will see more of these as they are. North Carolina has one too that has been introduced. And there's several federal bills. There's some that are, again, more tailored to a particular sector or a particular issue. And then there are others that are broader. And the big sticking points have been for the federal law, whether we would, the preemption of state laws, and also the scope in terms of existing sectoral laws. What do you do with HIPAA? What do you do with the use of the consumer protection law for privacy promises that were violated? So we'll see. There are a lot of advocates for privacy who want to see a federal piece of legislation. From the perspective of we'll have protections for all these people in all these states who do not have a state law. But if you're working on the defense posture towards this, you might want something that preempts state laws and provides less protection. There's also the other particular sticking point is whether there's a private right of action or whether this is strictly an administrative. There's some agency that will investigate, or maybe we allow state attorneys general to participate in investigating and bringing actions that could go to court that could result in fines. So those are on the horizon for us. Over in Europe, they have some other laws that are related to the GDPR, the Digital Services Act, which has been working on reducing cross-platform targeted ads. They are revising that as we talk, and there are certainly enforcement actions that people are watching to see what's going on with that under the GDPR, because there are some very high fines that are being levied against not just, we think of this as United States companies acting in Europe, but also some entities acting in Europe who are European, who are seeing fines. So the big addition for the moment is that there's a problem of getting data to travel from, it's not just the virus, to travel from Europe to the US, and there has been for a long time. European law requires a finding of adequacy of the law and environment, law and practices of the destination of that data. As you can imagine, the United States has not been found to be adequate. Now, we've solved that problem, we thought, twice with different, a safe harbor program with US Department of Commerce, and then a privacy shield, which has also been enforced some by the FTC. These are treaty-like arrangements that would allow companies to assert that they were complying, and so they would treat the data just the same as it would be treated in the EU. But as you can imagine, if I could see your faces, I would be going, so what do you think? What revelations may have kind of jeopardized a sense of comfort about having Europeans' data come to the US? And I will answer for you. That was the Snowden revelations. It's about US government access. In the EU, they allow government access for various things to EU data, but it has to be necessary and proportionate to the purposes. So they have not been thrilled with reports of just, we're going to read everything as it comes in and see if there's anything of interest. So there have been challenges to those treaties, those sort of arrangements, those agreements that we've had. And the European Court of Justice has said, yeah, no, that's not real. That's not working for us. And they said that Europeans require under their law a form of redress, like they need to be able to protest and bring a judicial claim that their information's been violated under the GDPR, and they want some remedies. So we have just like a week ago gotten an agreement between the White House and the Europeans about an executive solution for lots of complicated legal reasons that I'm happy to get into if you really want to go there. We really can't have a statutory solution to this because the executive branch is the one that does national security surveillance. So we have to have an executive branch commitment to providing this kind of support and avoiding the sort of harm that they perceive from the Snowden revelations. So what they're going to do is have a Department of Justice sort of tribunal that is administrative and doesn't have to go through the federal courts, and Europeans can challenge the use of their data and have a process for that. So we'll see that is a very hot topic, and they're calling it TDA because it's this transatlantic data flow agreement. Yes, it's very cheesy. Okay, so this is the last thing I wanted to say is, there are some things that you may want to think, well, so yeah, that's nice, that's interesting, there's a lot going on, what does it mean? So it does mean that the advertising industry is seeing a lot of curtailment of what has been the Wild West, particularly in the United States, because there are some limits, partly because of laws that require some consent and limitations, like California's has some limits, but also some industry choices. Apple changed what was the default on phones, and so they allow some prevention of cross-device tracking, and the idea is that this is spreading and it has harmed, Facebook showed some harm from its ad revenue, and so this is changing things. And certainly the law in the EU is focused on this as well. There are social and economic benefits of data use that are still quite compelling and are likely to continue to influence what goes on with the shape of the law here and there. And so that will be something that we do need to engage with and sort out if we can. Archives and libraries have secured exceptions for the right to be forgotten, or they call it erasure in the EU, and we may need to be paying attention more about that in the United States as some of our states pass deletion rights. And I would say that personal information use is still expanding through the use of AI, and there are many decisions that are based on inferences that are drawn from what may have been considered harmless, non-sensitive data points. You can derive a lot of very sensitive information from them. And then there's a lot of, and these are what we would consider privacy risks. Re-identification of anonymized data is getting a lot easier because we have so many data sets that are available either from government, open government transparency efforts, or from data that's sold. And so once you get some, similar data units elements, you can do what's called a linkage attack, and you can, boom, the peacock feathers fan out, and you've got a very rich and colorful profile that does identify a person. And I would say, hold the thought about collaborating with data sets, but we're looking to see what is going to happen with this new effort. There's a lot of joy about it right now, but it's no doubt it will be challenged again in European court. So we'll just see if that's gonna work out. And with that, I think I'm ready for any kind of questions or comments that folks might have. I don't know if that's something that, Gary, you can see questions.
Yep, I'm got the question panel open. Folks, please use the Q&A panel. I guess I'll start with something I guess I've been just struggling with, and that's what about all of my personal data that is being collected, not just through the search engines type services, but for something like patients like me, or
Good question.
I mean, or my Fitbit,
Yeah.
so I give Fitbit probably lots of permission, and they give me all these great reports, and I mean, I guess I don't worry about it too much. Should I be worrying about this? And I know it's different in the US than it is in the EU.
Yeah. Well, let's talk about the US, because that's where you're running, right? Where we're doing. The US, everyone tends to think, oh, HIPAA covers my healthcare data. But HIPAA is actually quite narrow. HIPAA was just, the privacy protections in HIPAA were an afterthought when we were trying to encourage people to be able to move from one job to the other and be able to have healthcare insurance. It's the Portability and Accountability Act, meaning that you should be able to have an electronic health record that can be easily moved from one employer's plan to another, so that you don't leave your data behind, and to encourage insurers to be able to have standardized coding. And then someone was like, that could be a privacy issue. So they just threw in some provisions that said, well, we need to go ahead and pass this, even though we haven't figured that out yet. So if Congress does not amend this in like 2 or 3 years, the HHS, the Health and Human Services, y'all need to come up with some regulations, which of course is what happened. So, but that has become what HIPAA is largely about in most people's imagination. But it only covers healthcare providers as defined under the statute, which is and only those that use electronic health insurance, health records. So, and then there's some clearinghouses that work in the background. There's a lot of data processing industry that we don't see all the time. It's invisible to us. Those 3 are covered by HIPAA. Fitbit, all these amazing apps, they have been regulated only through the Federal Trade Commission as the unfair, deceptive trade practices. And so it's not as stringent as having actual regulations under HIPAA. So what we do is, you see, the FTC will look and see, well, what is it that you promised? And they found that, frankly, there were some apps that actually were collecting a lot of sensitive women's health information about fertility and so forth. And they were sharing this information with, Facebook. And so then the data gets wrapped into those rich profiles and becomes part of the inference drawing. And, it's the kind of thing that it's kind of surprising how that information could be shared. So we don't regulate that very well yet. That is something that's pending in some of these bills, though, to see if we can regulate those more. And some of these apps have been called on the carpet, as it were, by the Federal Trade Commission for not living up to their promises. So you think that they have a pretty broad room to work within, because all they have to do is live up to what they promise they'll do. How hard is that? But apparently pretty hard. So that's a big area. And yeah, in Europe, it doesn't matter. They don't have this sectoral. If it's data about you, it's your personal information. And so it's a really different starting point and you have to use it only for the purposes that you originally got consent. And then when you're done, you're supposed to get rid of it. You don't just keep it forever and figure out what else you can do with it, which is kind of where we are. But, we have this thriving economy based on, data use and reuse and what else. I mean, if we've got it, what else could we do with it kind of situation. That's probably the time's gonna expire for that, because I think we are gonna see more states get on top of that. And there are some data broker state, well, I think, they're looking at just regulating data brokers. I think it was Connecticut. I'm sorry, I can't remember exactly which state. Somewhere in New England is looking at data brokers. So because those folks then vacuum up a lot of this data that you didn't share directly with them, but they were created, the whole data broker thing was created for good reasons. A lot of these things are good reasons. If you didn't go to the country club and sit next to the bank president, you probably didn't get a loan. Back when these companies were created, the idea was to equalize access to credit. But what has happened in the data age is that they just have a whole lot of data, and it's shared for lots of different reasons.
Yeah, it sort of sounds like what we need almost is a whole collection of IRBs that we do every time. But that's not going to happen. Yeah, there's a question from Kim Stahl. I don't know if you can read these.
I don't. So, oh yeah, now I see. I can look at this. Yeah. With reidentification becoming easier, do you have thoughts on how organizations should consider how they set a data classification and corresponding protections for person information in context that wouldn't otherwise seem as concerning as health and finance? Great question. So I'm not as expert as some on this, but I have some thoughts about this. One is that although it's somewhat burdensome, you should be able to pseudonymize data. You can have a stand-in for some identifying. It's tough because so many different things can identify people. But if you can use some of that so that if you need to go back and actually have names and what other social security numbers and home addresses and other identifiers that you could, but otherwise you kind of move out a bit from that, and then you could do it. Another strategy is to, when you do de-identify data, like you would under HIPAA, there are regulations. I think there are 18 identifiers that you can redact and make sure there's nothing else that you know of that could trigger a re-identification. Then you can release it, and it's no longer protected. It's gone. It's out there. But if the problem is that you can take a look at what exists at the time that you release the data, but next year there could be 3 more data sets that are also released that can be used for linkage attacks. So I don't have a great solution for that. It's a risk. Now, many people say it's not a great risk because the only people who are really doing this that we know about are journalists and computer scientists who work in this area. But my answer to that is, how would we know? How would you know that? If you're back there and making a whole lot of money out of re-identifying or using supposedly de-identified data to enrich your data sets, you're not going to go publicize that, because that's obviously, a red flag for people. You're not going to get to keep doing it as much because that's what triggers regulation. But there are other strategies, and I did do some research at one point with Professor Andrew Chin on a technique that's called differential privacy. And the idea is that you have a query to a database, that you don't work directly with it, but you have an intermediary and you query the database to find out what you want from the database, and it sends you a pretty close answer. There's an N that can be larger or smaller that introduces what technically is not noise, but for those of us who are not experts in this area, it's like introducing noise, but can still give useful feedback. So it depends on the use of the data, whether you can de-identify it for certain uses. But I think that there are people working on this. It is a very important area right now. So good question.
I'm wondering about what the implications of the kind of quilt is for libraries and archives in the U.S. who might have data that actually came from the EU, either historical data or things that are part of ongoing scholarly agreements, or what can we do to kind of prepare or protect ourselves?
Good question. Well, one of the things that the EU does in their GDPR is it only covers people who are alive.
Okay.
So there is a point, and I think this is a really important one, and that's largely the case in the US too. Even census data in the US gets released after a certain period of time, even when some of those people might still be alive if they're fortunate. So that's one of the things that helps us. The other is that while they will apply the GDPR to European to data about Europeans collected, there is a whole lot of good faith negotiation habits within the EU. They have these data protection authorities in each country, and there's a lot of consultation. It's kind of different from the US. In the US, we really have a sort of fierce adversarial kind of context for some of these things. But in the EU, you really could probably say, oh gosh, we did not realize we had to go back and do something with this. What do you think we should do? And then try to solve that problem. There are still also many exceptions, some of them that apply directly to archives and historical issues in the public interest. So the librarians and archivists in Europe really mobilized in that marvelously quiet way that we all tend to do, and worked exceptions all over the GDPR for archives purposes. So it's really a robust sort of protection for that sort of thing, so that the right to be forgotten is not forever. Now that you do have to delete things if it's a person and it's not, you don't meet one of these exceptions. But often libraries should meet those exceptions. The main things that libraries were worried about when I got to Helsinki, it was 2019, and the GDPR had only just taken effect in May of 2018. So they were all still kind of scrambling to figure out, I don't want to make them sound, everybody was still trying to implement the many different requirements. But one of the things they were worried about is like author names of live authors in the catalog. They were really trying to work that out and make sure that that was okay. Because they have birth dates, I get death dates, as we were just saying, shouldn't matter, but birth dates kind of matter. If there's no death date to go with it. So they were really more worried about that and not worried so much, because I was really worried about if you do a digitization project, you're going to enhance access to information. And that's what a lot of libraries are doing, not just here, but also in Europe. And so I found out that they're really they worked to shape the GDPR to accommodate that. And that would be something that we may have to really get more engaged in as these new laws are pending. So, and may I pick up on something that you just mentioned about the IRB? Okay.
Yes, sure, of course. Yeah.
Okay, so the IRB internal review board is what is created in institutions that, and of course you know this, Carrie, but the way that comes to be is that there is a federal regulation that's called the Common Rule, and it is a rule that is adopted by, I think it's 10 different agencies that fund things that include human subject research, and they require informed consent and several other things for treating personal data. And you're absolutely right. That is a very important way for us to think about drawing on that to shape some broader law. But we have so many of these. There are so many of these little piecemeal laws that it's quite difficult. And that's one of the reasons it's hard not to be sympathetic with, even though, the big corporation with lots of power and money is less sympathetic, but the idea that it is really hard to comply with all these different things is part of it. But the IRB is a really great, and it grew out of all those ethical messes. We did it wrong for so long, and then figured out how to do it right. So there's hope for humans yet.
Well, on that note,
yes.
As the eternal optimist, I'm happy to hear that. I just have one other question, if no one else wants to chime in, and that's when you were in Helsinki, did the issue of student data, I mean, I assume it all falls underneath sort of the GDPR rules, but did they do something even more special with, say people under the age of 18? Like at least here we have, the FERPA sort of rules that supposedly protect student records.
Supposedly, it's good. So we have FERPA, and then we have the Children's Online Privacy Protection Act, which governs outside of the educational context somewhat, trying to get parental consent for those 13 and under for access to some online content. But FERPA is ours. In the EU, and I'll talk a little bit about FERPA, because the EU would they do have special protections. It's considered sensitive information if it's about children. And to my knowledge, there's not something that says specifically in the education context, but I just could have not, dwelled on that part of the GDPR yet. But I would think that the students would be protected, and they would have to have information collected only for a particular purpose. And then they would not be sharing that widely, because you cannot share beyond your, you wouldn't be giving that information to the press or that sort of thing. So that's inherent in all of the kind of collected data. Now, in Helsinki, the Finns, they love technology, and they very much trust their government. They're a young democracy, like 100 years, and in celebration of their 100-year anniversary, they built a public library. You got to love these folks. So it's a big modern public library in the center of Helsinki that won Best New Public Library of the Year award when I was there. It was fun. But they really they're building a smart city neighborhoods that do collect a lot of data about people, but they do it with consent, and people have a better sense of trust because they don't feel they know more about who's getting their data and how far it will go. And the GDPR kind of encourages that. The idea is you have restrictions that allow and support more of these innovations. So we hear a lot of pushback over here about, oh, we can't have the EU, they can't do anything innovative. And it's like, well, that's not how it can induce more participation and reduce the some of the more iffy secondary, tertiary applications of data that's collected to create, profiles that seem to discriminate and, just share things about people that are sort of beyond the pale. But in terms of FERPA, that's one of our weakest laws, sadly. It doesn't have any enforcement except that they can withhold the federal Department of Education, if they find a pattern or practice of violation, can withhold federal funds, like student loans, everything. You're cut off. So it's so bad, it hasn't happened, So, but we still tend to respect it, and people do talk about it and rely on it. And the department works very hard. They put a lot of their resources toward educating and supporting schools to do better at not posting a lot of stuff out there that should be kept protected. So yeah, children though are the place where we start to do a lot of our protecting. That's where we had some of the earliest right to delete in this country, and California had one where when you, as a child, if you posted something on a website and later regretted it, you could go back and, assuming that platform was still around, and you could go back and you could only delete what you put on it. So it's very limited. But the idea is we do more for children, and that's how a lot, like targeted advertising in Europe, they've reduced some of the scope of what they were going to do and now are focused on children. So children, definitely, we're trying to see heightened protection. Although I will concede that I have a student in my class this time writing about sharenting. So, there's not much yet that we can do when parents are the ones sharing all the information about their kids. Yeah, it's a thing.
That's a new term for me, sharenting, huh?
Sharenting, yeah. So yeah, this is not I realize that it's complicated, but it is a very interesting area because there's always something new that's being done with information about people. And for good, for creepiness reasons, who knows? We're trying it all, and so it's fun to see where it's going to go.
Well, and this has really been fascinating. Thank you so much. Really, not just a hot topic, but a complex one, and you did a great job of really setting up these contrast between the EU and US law, and I certainly have learned a lot. I want to shout out to a bunch of SILS alumni out there. I'm glad to sort of see your names at least in the list here, and thank you once again for a really thought-provoking and informative lecture today. And with that, unless somebody has a last word, I'm going to thank everyone and enjoy the rest of what, at least in North Carolina, is a sunny day.
Oh yeah, thanks everybody. Take care. Good to see you, Gary. Bye.
Bye-bye. Great job.